Struggling to communicate with your co-parent? That's why Peaceful Co-Parenting Messenger was created. It's a communication tool for all co-parents, but especially those who are in high conflict situations. I always tell co-parents who ask, sign up for Peaceful Co-Parenting Messenger as early as possible in your separation and divorce process, because you never know when you're going to need a more robust communication tool that allows you to set boundaries on the communication you have with your co-parent. Are you getting messages that look like War and Peace? It's not a text message. It's the length of a novel. Set the brief chat limitation in the app and keep those messages short and to the point. It's about the kids, right? Keep the focus there. You can also limit the number of messages you receive in a day and other nice a la carte features meant to bring sanity to your life. You deserve that, and your kids do too. Peaceful Co-Parenting Messenger in the Apple App Store and soon in the Google Play Store. Go to peacefulparentapp.com for more information.
This week on Peaceful Co-Parenting Podcast.
If they can get to me first, okay, before they hire an attorney, then I can form a plan of what they need to tell the attorney they want done. See, most people approach an attorney in a different way because I'm legal savvy. So when I call a lawyer, I tell them what to do because I know the system. I don't ask them. I tell them. It's like, hey, I want you to subpoena this. I want you to get that. I want these medical records. I start dictating what I want done. There could be some really important things that the would-be client does not told me that might benefit their case, but they just didn't know because This is a new experience for them. So they may be sitting on a gold mine of information and not know it and not even convey that to an attorney either.
Welcome to Peaceful Co-Parenting Podcast, where we discuss strategies and tips to improve your co-parenting situation, especially if it's high conflict. I'm Bianca Balogh, co-parent, mother, and entrepreneur, creator of Peaceful Co-Parenting Messenger app, and believer in turning challenging situations into something positive.
Welcome back to the Peaceful Co-Parent Show. I'm your host, Bianca Balogh, and I'm so happy to be with you again. Joining me tonight is the child custody guy. Guy White is coming to us from Arizona. Hi there, Guy. How you doing tonight?
Fine, thank you, Bianca. Thank you for having me on your show.
What's going on in Arizona?
Heat.
I'll bet.
Plenty of that.
So I'd like to tell our viewers a little bit more about you and give you a proper introduction. Guy is an expert in child custody cases. He is a former military man and spent some time serving in the Army. He has over 30 years of experience guiding parents through child custody disputes. He used to have his own radio show and ran a father's group in the mid-1990s. He wrote a book called Child Custody A to Z. He consults on child custody cases and guides parents to self-study with an online strategy for winning their cases on his website. So happy you're here, Guy. Would you like to add anything to that introduction?
Well, thank you. Yes. Well, I wrote the book quite a while ago, published in 2005. And then with all this material and all this experience and working all these cases all over the country, I put together a course. And the course is very comprehensive. The book is good, of course, but the course is just 10 times more detailed than the book. It's hard to cover everything in a book, every scenario and everybody's case, because everyone has a different case, different dynamics of their case. So one size doesn't fit all. But what I tried to pack into this online course was every angle I could from all the different cases that I've worked on. So if someone was working on it, they'd say, oh, okay, this fits what I need to do on my case because my children are this age and you know, the occupations of, you know, our spouses are this or that, you know, and I'm having trouble with my lawyer, but this guy's telling me how to work with the attorney in the course. And so it's really comprehensive. It shows a lot of different things, custody evaluations, how to deal with guardian ad litems. You know, I had a good time doing it because it's a video. And so people can watch it, but there are some notes and workbooks that are along with the course. to keep people on track. And it kept me on track too. And then I'm coming out with a second edition of my book next year, which is
nice.
going to be, it's going to be more comprehensive than the book I had before. The concepts of my book never change. Gathering evidence in child custody cases, that's never going to change because it's a court system, and a court system depends on evidence, or should depend on evidence, to determine the outcome of a case.
Yeah, I hear what you're saying. So every case is unique, but what you offer in your course and your book, there's like common threads throughout that will really resonate with people, and they'll be able to find their way and guidance with your information.
Yes. Well, in the book, I talk about different types of evidence, but technology's changed now. And so with the technology today, what was maybe wasn't evidence was available in 20 years ago. 2005 was when I ultimately published the book, but I wrote it before that. And then the technology today, is completely different because we have such an automated lifestyle, and collecting evidence with that automated lifestyle, I include that in my online course because I want people to have an open mind and use their imagination of what evidence they might be able to use in their case.
Mm-hmm. Yeah. Great. So we've got our first question from a viewer. So Mariah asks, have you worked on a case in the UK by any chance?
I sure have. And my book is actually sold fairly well over there because in the case I worked on was very, very similar to here in America, where a custody evaluation was going to determine custody in the case, which is very common here in the States.
Mm-hmm. All right. So let me dive in with my first question, and it'll give our viewers a little bit more information about you. Can you start off by telling us about your lobbying efforts 25 years ago for equal shared parenting in Arizona?
Yeah, I had a fathers group in that we had all these volunteers, and we put together this fathers group, and then we put together a lobbying effort. And what we were trying to do was tailor our bills after, I believe, it was either Wisconsin or Iowa, but at the time they had the presumption of equal access law. And so we were trying to get that passed in Arizona, and that was in 1996. It just got passed in 2012. So it took a while, but it finally happened. But the good news was that we really put the information on the table. We were able to articulate an argument that really made a lot of sense. And we included all kinds of buffers of criminal records and things like that. Title 13 here in Arizona, that if someone's a convicted felon and this and that, the presumption wouldn't be equal access, but that does not negate them from having a relationship with their child. It's just something that needs to be looked at. So, but what I found is a lot of these states are doing the presumption of equal access. And so now evidence is still important, because if we're starting off with equal footing, then and you have a parent that really doesn't have the skill set to have the children 50% of the time, then you're going to have to put some evidence together to be able to rock that boat.
So why did you put yourself out there on an issue like that?
Well, I grew up without a father, and I had some friends that got the bad end of the justice system. And so we decided that enough was enough. We had a lot of people being arrested for violating orders of protection that they never violated, a lot of false allegations. They were just really having a difficult time having a meaningful relationship with their children. So we thought, hey, well, let's try this. Let's see if we can try to get off on equal footing. And what we built in there was at 5 years old and older. We didn't even try to go at the infants. So we were really compromising compared to what it is today, because today in Arizona, the presumption is equal access right out of the gate. You don't have to be a 5-year-old or a 2-year-old. It's right as soon as the baby's born, pretty much. So that's a different concept, and I think it's a good one, because I had a father that wasn't doing well in a custody case one time, and and he was a pediatrician. And and they're saying, oh, well, he's dangerous to the child's welfare, but yet what does he do? He works with children every day, and takes care of them. And it just didn't make any sense. So but allegations do not equal reality, but you have to fight them, because some of these false allegations will stick to people like super glue.
It sounds like Arizona's come a long way. You've had a lot of experience. What makes you a child custody expert?
Well, what makes me a child custody expert is because of my education. First of all, I grew up without a father. Secondly, I've raised children. Thirdly, I've been a forensic investigator for many years. I originally started as a criminal investigator when I was in law enforcement. And when I got out of military intelligence in the Army, I started a private investigation and security business. And right away, I started working a lot of child custody cases. And from working those child custody cases, I started to see what attorneys weren't doing. In other words, they weren't using evidence, even evidence that I was collecting that in other cases actually proved to be a benefit in the case. So I'm thinking, well, there's a disconnect here. And a lot of the cases are being decided basically by custody evaluations. That means psychologists are determining custody, not judges. Judges didn't want to make the decision because they can't get into the details of a family that has a complex or high conflict case. So they would have a custody evaluator. Well, that custody evaluator is only as good as the information that they have. And so the psychological testing is nothing but a snapshot of what people's lives are. And so what did I do? I jumped in there with evidence, and having that evidence was superseding anything that the custody evaluators could come up with.
Okay, so I've got some questions for you. We have a viewer question. Let me jump into the viewer question first, and I'll follow up with my question. So what is your opinion or thoughts on the progress across the country since you lobbied in Arizona?
There's been a lot of progress. I work a lot of cases in Florida. Fathers have a very, they get a lot of time, I won't say the lion's share of the time, but it's equal access in Florida. Minnesota, I've worked there. I worked all over the country. California, I've worked tons of cases there. It depends in California by county. Each county in California is its own little country when it comes to custody. So San Diego is going to be different than Orange County, and LA has been pretty father friendly. But I've worked in San Bernardino and some of the other counties, and they haven't been as father friendly as LA. And so it just depends on which county you're in that I found in California, but it's a huge state. In Florida, which is large too, but they've been pretty father friendly there. So I think there's been a lot of progress made. Is it perfect? No. Is there some states still behind? Yes, there are some states that are still behind the 8 ball there, but for the most part, there's been tons of progress.
Okay. So we've got a lot of people watching that are going through child custody disputes themselves. What's your biggest piece of advice for them?
Well, the first thing that I put in my book, the first chapter, was control your emotions. Because if you don't control your emotions, then you're no good to your children, and you're not going to make rational decisions, and you can fall into a trap, by losing your temper and saying or doing the wrong things that might stick to you for quite a while. So you can make one bad chess move in a child custody case, and it can haunt you for years. So that's the first thing you do, is control your emotions.
Yeah, that's hard to do when you're in the thick of it, right after maybe the end of a relationship, and emotions are high, right? And you're trying to figure all this stuff out. So that's a tough one. Easier said than done, probably, right?
True, but then, in my course, I talk about ways to control your emotions: exercise, confide in people that you trust, because you need that release of what's going on. But educate yourself, because instead of being a victim, refuse to be a victim and educate yourself on custody. And that's one of the reasons I wrote the book, because I wanted to let people know that I do know the system. I do know that there's bad lawyers, there's bad judges, there's bad custody evaluators, there's bad guardian ad litems. It's an imperfect system. And so I do go after the professionals in my book, because they're the ones that have been controlling the chess pieces and they haven't been getting it right.
Okay, so you said you go after the professionals. What does that mean? Like,
Well, I criticize them for their being inept at times, and just getting it wrong, because it's a snapshot. When you're going to do a custody evaluation on some parents, you're going to give a psychological test. That psychological test they use as a Bible, okay? And so, if like the MMPI-2, the Minnesota Multiphasic Personality Inventory 2, which is the most common test that they use to decide for custody evaluations, which ultimately they decide custody because they're going to recommend this to the judge, the court, what the arrangement should be based on their limited scope of a custody evaluation. So that's why, I teach people how to impeach court experts if necessary, because they may get it wrong. And if they get it wrong, your children have to live with it.
All right. So you go after the professionals, and this, as you said, doesn't make you so popular sometimes.
That's right. Well, but everyone has critics, but there's no monuments for critics.
All right. So where do you start when you begin building a strategy for someone in a child custody dispute?
Okay, so in a child custody case, when I do an intake, so to speak, I need to know a little bit about it. I give people a 30-minute free consultation when they call, and I determine whether or not I can help them based on how they describe the circumstances of their case. In the event that I think I can help them and they want to hire me, then I need to see all the paperwork that's been filed in their case, so I can see for myself what's really going on, what they're accused of, what they're not accused of, try to get an idea, get a flavor for the case, because there could be some really important things that the would-be client has not told me that might benefit their case, but they just didn't know, because
Sure.
This is a new experience for them. So they may be sitting on a gold mine of information and not know it, and not even convey that to an attorney either.
All right. So you dive in, you look at the information, you see if there's, anything in there that they might be missing that could be really beneficial for their case. How about, what is your advice for picking a good attorney during a difficult time like a child custody dispute?
Yeah, and that's a really tough one. So here's what I try to do for my clients. If they can get to me first, okay, before they hire an attorney, then I can form a plan of what they need to tell the attorney they want done. See, most people approach an attorney in a different way, because I'm legal savvy. So when I call a lawyer, I tell them what to do because I know the system. I don't ask them. I tell them. It's like, hey, I want you to subpoena this. I want you to get that. I want these medical records. I start dictating what I want done. But lay people that are not legal savvy, when they get into these custody disputes, they don't really know what direction to go. So the attorney controls everything. And the biggest complaint that my clients have is the attorney won't listen, or they won't do what I want. So I said, if you get to me before that, I will teach you how to choose an attorney. And then what I want you to do is get a contract for services for the attorney. And they said, what do you mean? I said, well, what I want you to do is I want the attorney to agree is that they're going to do A, B, C, D, E, F, G for you for your custody case. In other words, I go in with the plan because they don't have a plan. I'm working a case in San Diego right now, and we've been through 3 attorneys because none of them have a plan. Now, I formed a plan, but we finally found one that's actually going to do the plan that we want, because the things that the records and cell phone records and different things that we want to accomplish to show the lifestyle of someone to get a better deal out of this, these attorneys weren't willing to do it. So you want an A-type personality. You want someone that's, if you're in a high conflict case, which is why people call me. See, things, if it was going well, they wouldn't be calling Guy White.
Sure.
Right? Because they call me for the high conflict stuff and they need some help. So that means that you need an A-type attorney that's willing to go in there and be assertive.
Absolutely. So you got to have a plan, and you want the plan first, then you find the attorney who can follow up with the plan.
That's exactly right. You're just giving them a script. See, I get so detailed into these cases. I mean, I write deposition questions. Okay. I teach my clients how to respond to emails and text messages. Take a deep breath. Don't respond right away.
Right.
Because
give it some time.
Again, these are traps. If they're going to call you back and accuse you of something, let the phone ring. Let it get on the voicemail of your phone if they're going to threaten you. So now you have a record of it.
Now you got some more evidence.
That's right. So that's just part of the evidence collection campaign, if you will, that I direct my clients to do. And I have them create a diary. So we have a chronology of events that have taken place.
Absolutely.
And so I work them. And then we get to the package. And the package is the package of evidence that can really make a big difference in these cases if it's used properly. But it has to be used properly. And timing does matter when you use evidence.
Excellent. I want to come back to a few points, but Mike White has a question for you. He says, do you have advice for enforcing parenting time when one parent does not follow the custody arrangement? I'm not sure if the child.
Why is my brother commenting on this?
Is that your brother?
No, it's not. No, my brother's Tom.
Oh, that's right. It's your Guy White. This is Mike White.
Right. Yeah. Okay. Okay. So advice for enforcing parent time. Okay. So there's 2 things that need to happen here. One is anytime you do a custody agreement, you want first rights of refusal. That means that if mom's going to out of town for days at a time or a weekend or whatever, you should be the first choice of having the children be with you and have that in your custody order, because it gives you, she can violate that, and then it gives you some leverage. Secondly, if someone is to enforce the parenting time, you need to file a contempt with the court that they're violating it. My experience is judges don't want to see it if it's just been one time. You want a pattern of behavior of this going on. So you want, several times, and then you want your makeup time. Okay. And you request makeup time. But Mike White, one of the traps you can set, so to speak, is, getting on you want a record of it. So email, they don't respond. Email again, as we talked about before. They don't respond, give them a chance. They don't give you makeup time. Now it's time to use your emails and text messages and file a contempt that you've been denied access. And, sometimes I have my clients call the police because they have a court order to see their children and they need to make a record of it. And so having a police report number might be an option
Sure.
to document that.
Sure. Yeah. If you call the police, there would be even more evidence in addition to the text messages and the emails. So very good. Very good. So Guy,
How do you feel about the training for family court personnel that they receive in regards to our topic tonight?
Training, you mean to deal with these difficult high conflict situations?
Yes. Yes.
Okay.
Do you feel they're trained and qualified?
I it depends. It really depends because there's I've seen custody evaluators here in Arizona, and I work all over the country. But I've seen custody evaluators here in Arizona that get it right a lot of the time. I know them personally because they're very detailed about their work, but they're court appointed, and so they charge a lot of money, so they're not part of the government system of mediation or anything like that. Um, but the government's not equipped, as usual, to deal with all this conflict. It's just too big. The numbers are too big. That they can't assimilate it. They can't get it done. Even if they were well trained, they don't have the time. So it's an assembly line process when you use the government for mediation in these cases.
Mm-hmm.
And so I think, and this has always been, my beef with, and why my book's done so well, is because evidence really matters in the justice system if it's prepared properly. Take a criminal case; it's all about evidence. A personal injury case; it's all he ran the red light, or she ran the red light, or the plane crashed, or whatever. It's all about evidence. Why isn't child custody about evidence? It's not until I get involved. I see this all the time. I mean, I work cases and I'm thinking, why didn't they do a hair follicle drug test on this person? It's so obvious that this person should have had that. And it didn't get done. Or the lawyer says, well, if we do that, then you have to take the test too. And I'm like, of course. Well, then what's good for the goose is good for the gander. But of course, everyone gets tested. But if there's somebody that's impaired all the time with their children, I think that's relevant to the stability of the children and the parent.
Yeah. Well, let's talk more about evidence. I just want to let Alicia Ramos know that Guy White does work all over the country and internationally with his services in child custody disputes. So thanks for that question. But yeah, let's dive more into evidence, because seems to be your specialty in getting the right evidence. A lot of times these cases are he said, she said. So you mentioned a hair follicle test. What other evidence would you say is important in child custody disputes? You mentioned text messages, emails.
Absolutely. So that's obviously police records would be relevant. And I was working a case in Florida, and it's a law that you have to have a fence around the pool, and there was no fence around the pool. So I had my client take pictures of the fence around the pool. We made a big deal out of it because the child's so small. And there was a lot of swimming going on. I want to teach my kids to swim. That's fine, but you need a fence around your pool. You got big dogs, knock the poor child in the pool. There's imminent danger that comes to mind in some of these things, or any activities that you're going to have your children involved in, and that can be dangerous. I mean, I have horses, but horses are dangerous.
They can be. Sure.
Yeah. I mean, I watched a little girl fall off a horse with her mother one day. And this is a very tall horse. It was nice that it was soft ground when she landed on her head, so with no helmet. So there's judgment calls here sometimes, that, so putting your children in jeopardy with bad decision making, or imminent danger, which is usually what the law is, imminent danger, can change the outcome of a custody case based on putting those children in danger. But to answer your question, proving drugs and alcohol and things like that, I mean, I've coached my clients to hire investigators to go through trash, do surveillance, whatever it takes to prove what's going on here. If you're at Chuck E. Cheese's drinking 4 pitchers of beer or drinking margaritas after the Little League game and carting those kids around, that's a problem.
Mm-hmm.
And so these are things that lawyers don't think that way because they're not investigators. And that's the gap in their education for the most part. They're not trained psychologists. So we have a system here, Bianca, and this is one of the points I like to make to people. And that is, when you go to an attorney, they may know the child custody game really well, but are they trained in personality disorders? Probably not. Are they trained in gathering evidence? No, they don't do that in law school. They only talk about the admissibility of evidence, but not how to collect it. They have to leave their office. See, the lawyer's not going to leave their office, okay, to go out and do what I did one day. I had someone call me and I wanted to prove a parent had been drinking. I went to their home. It was gated community. I thought, boy, it's going to be difficult to empty the trash here and prove the alcohol problem. So I looked for the closest grocery store, and we subpoenaed the food reward card and found out the mother was drinking 3 liters of vodka a week after she had stated in court she hadn't drank in 6 months. That's creativity and imagination. And this is what changes these cases. And so that's the reason why evidence is so important. And if you don't have any and there's not any out there, well, then it saves you money too, because then you're basically saying, well, this parent's not that bad. So there's no reason to, spend 20 grand on a lawyer fighting over something that's, small, then you actually saved yourself some money because you don't really have a case. So the evidence determines whether or not you have one.
Okay. All right. And so how does a therapist play into the evidence and documentation?
Okay. So what happens we need to bifurcate this just for a minute, because there's a guardian ad litem that gets assigned to cases throughout the country. And there's also custody evaluators. There's also parenting coordinators. There's best interest attorneys. As you can see, there's layers of all kinds of things. And then California, they have a 3-tier system of dealing with child custody cases with different types of therapists. So it gets pretty crazy. Having said that, the key is, and this is from my point of view when I work a case, is if you have that set of eyes and ears on your case of a custody evaluator or a trained counselor or a trained psychologist with a PhD, it's our responsibility to get as much information to that person as we can to reveal what's really going on in the case. So in other words, instead of the custody evaluator just giving you tests and trying to figure out what's going on, we're going to load you up with the evidence, the police reports, eviction notices, medical records, phone records, financial records can prove lifestyle. And so you definitely have to, again, analyze and be creative and what fits your case based on who you're dealing with. And the other part of this is if there's no evidence from that point of view and you have evidence that more from the standpoint of a personality disorder, someone who's so oppositional and so difficult to deal with, then that evidence collection is going to be your emails, your text messages, things filed in court, court testimony possibly, previous court testimony, other spouses that they had problems with. Everyone has a story. Everyone has a history that needs to be unraveled and put that in front of a therapist.
Okay, great. Good stuff. And so Chris Rose asks, how can I use mental disability and alcohol abuse when the judge refuses to see the documentation proving mental disability?
Okay, so when people ask me these things, I have to know what went on in court, because there's a thing called hearsay evidence. So hearsay evidence may not be admissible where you are. So I have in my course a thing called authentication of evidence, where I teach people to authenticate the evidence so the judge has a problem if they don't look at it, because then it becomes an appeal issue, or another thing called a special action, where you just, you're going to appeal the case in a different way. There's a couple different options for appeals, and that's for the lawyers that you need to hire to do that, because I don't do that, but I'm letting you know it exists. But the evidence needs to be authenticated, and sometimes you're going to have judges that are going to ignore things, and and my clients have had to appeal cases on occasion because you're going to have a bad judge. So this system is not perfect, and so it's like pulling teeth sometimes. You just have to grind it out, and then if that judge ignores it, then you have to. Plan B is finding an attorney that will challenge it, try to appeal it, set this aside, or come up with new evidence that's so overwhelming that they can't dispute it. So just don't give up.
And so you've said that the court system is a scam. Can you explain a little bit about that?
Did I say that? When did I say that? Well, the court system is set up for compromise, mediation versus litigation. Okay. So when you have all these layers of things, of all these people I just mentioned to you, okay, it creates kind of a cottage industry, because what we have is a therapist for the children, a therapist for the dog, a therapist for the mother, a therapist for the father. Everyone needs counseling. According to what? You know what I mean? It's like, so that's expensive.
Yeah.
And then you have the parenting coordinator, and then, you have all of these layers of people that get to do something here on your case. The judge says, oh, well, you need this in that case, and you need this parenting coordinator so you guys can kind of, mediate all your issues, co-parenting and this and that. But that gets expensive. And so where the scam is, where you have all of these people deciding the fate of your children, and it's costing you a bundle. And the question, is it necessary? No, most of the time it's not.
Mm-hmm. Mm-hmm.
So that's where the scam comes in.
Okay. And so how are child custody matters different from other domestic relation issues?
Well, I don't do divorce. I'm not an attorney, so I'm a divorce expert. I know I've lived through thousands of my clients. My focus is child custody, how to coach my clients to get a better deal, to win sole custody when it's necessary, when there's enough evidence, strategize on how to get their children in a better home. So there's so many different domestic relation issues, because there's physical abuse and mental abuse, and there's all kinds of things that go on with people.
Yeah.
But that becomes evidence too if you use it, because you need to be able to provide a safe place for your children.
Yeah, I was going to say that could factor in too and cross over into the child custody case.
Absolutely,
for
sure.
Yeah. So what's your approach to cases? Offensive, defensive? How do you like to approach a case?
Well, first of all, one of the things that has happened with the fathers that I've represented and consulted and coached over the years is that they don't think they can win because they've lost so much and gotten so much bad advice along the way that they don't think they can win because they've always defended themselves, and they haven't been offensive, and they haven't had an attorney do what they're supposed to do. An attorney is supposed to advise and advocate for their clients. They need to believe them. A lot of times they don't believe them.
Mm-hmm.
And so because it's I won't say it's easy listening to people's problems all day long like a divorce attorney does. But you chose that. And so if that's going to be your vocation or your profession or your occupation or however you want to describe it, then you need to listen to your clients or get out of it and go do estate planning.
Yeah. Yeah. So let's take this question from a viewer. So how do you find an attorney that's willing to fight for you? Mine have historically left me hanging and have done as little as possible on my behalf.
Yeah, that's really a tough call. And I will tell you that I worked for a guy in Beverly Hills that he was so tired of paying lawyers that did lousy work that he just hired me to help him, and he ended up taking his wife's deposition. And I helped him write the questions, and we subpoenaed some records of where she was living in her apartment and found out there was 23 complaints about her using foul language in front of little kids and being obnoxious and being irate and so on. But we subpoenaed those records. So sometimes you can go without an attorney, but when you go without an attorney, you need a paralegal that specializes in domestic relations, so they know what motions to file and so on and so forth. But it's really difficult to find. We have generations of change in the legal profession. Jerry Spence was the most winning attorney probably in this century, and most people don't know who he is, and he's 90 years old. I've talked to attorneys, and I said, "Well, I'll buy you one of his books," because I worked for him many, many years ago in a case. But this guy was famous in the old days and was just an awesome attorney. I wish there were more like him. People that have passion and people that have a backbone and to help their clients. And you don't see that today. So this is a dilemma from this last question. It's a dilemma because when I work all across the country, I've worked for attorneys, okay, that hired me to consult on their cases that have trouble finding an attorney that they trust. I had one here in Arizona, and he read my book. He called me, and he worked for the government, and his name was actually on the building, and he couldn't find a lawyer to save him. I found him an attorney to help him with his case, and he wrote about it on Amazon when he reviewed my book about it, about how troubling it was for him to find an attorney, and he's an attorney. It's just the problem of finding someone who has that backbone, for lack of a better word, that's tough enough to deal with the conflict. Because when there's conflict, you need someone that will fight for you.
Yeah.
And just sending letters and playing patty cake isn't cutting it. And see, this is what goes on all the time, this little patty cake back and forth. The shortest distance between 2 points in a custody case is evidence, because evidence is what determines the outcome of a case in our justice system. Except in child custody, it doesn't get done because nobody knows how to do it. Nobody's out there doing it. And there's lifestyle Uber records. I've used Uber records for people that have alcohol problems that constantly Uber to prove that they're never home. I will scrap at anything to help my clients being creative here.
Mm-hmm.
Okay. And of course, prescription drug abuse. There's so many venues and avenues of evidence here that's hardly ever uncovered and not utilized. And of course, I have to bring up the marijuana use because it's legal in a lot of places, but it still impairs you. Why else would you smoke it? You smoke it to be impaired, right? Just like people drink too much alcohol to get impaired because it does something for them. Well, if somebody wakes up in the morning and smokes pot, and then they smoke pot, a couple hours later, and they smoke pot a few hours later, and they pick up their kids from daycare, I would say they're impaired, because you make that same comparison with alcohol. You get up in the morning, you have a few drinks. Lunchtime, you have a few drinks. Afternoon, you have a few drinks. You go pick up your children at at daycare. You're impaired.
Yeah.
So I think this needs to be looked at. That just because it's marijuana, because I've had attorneys tell my clients, well, marijuana is legal. Well, yeah, so is Xanax. But if you take 10 of them, you're probably going to be impaired.
Sure.
Right. I mean,
Right.
there's a lot of things that are legal. You be addicted to ice cream, I don't know. But I'm just saying, this gets silly when someone's abusing something. Then, it's impairing their ability, in my view, to be a good parent.
And it could be a part of that evidence. Yeah. So Chris Rose has another question. Can a judge overrule another judge? He says, my first custody case, the mom filed domestic violence against me and the judge threw it out. So she changed the judge and used the same defense and won.
Well, Chris, you can call my office here. It sounds like we can have our own show together. Yeah, you would think so. Again, when getting into the legal decisions here is not really what I do. But in my opinion, when a judge has made a ruling of that the DV was thrown out because it didn't meet the standards, there wasn't enough evidence to prove that it was, then that should not be, a judge already ruled on it. I would think that you could file something to try to set that aside on the basis that another judge get the transcript, track down the decision on the first one.
Mm-hmm.
I don't know how much time's gone by or whatever. But, when you get false allegations against you, you need to confront them right away. And this is something that never gets done, Bianca, because fathers tend to, they're so busy defending themselves. And their attorneys will probably say, well, don't fight the restraining order protection, whatever it is in your town, or, that'll just upset the judge or whatever. Well, if it didn't happen and they lied on the paperwork, you fight it, because if you don't, then the judge has to assume it's true, don't they? Does
Sure.
that make sense?
Yeah.
So you're not going to, someone files something with the court and says, Guy White's a dangerous man and carries guns and, and road rages and takes steroids or whatever they're lying about. I'm going to fight that. I'm going to go into court. I'm going to get my attorney, or I'm just going to go myself, but I'm going to have a hearing and put that person on the stand and say, prove it. Prove that I'm on this. Prove that I do this. Prove, hearsay. That's where hearsay should not be allowed. See, so it's the thing about hearsay in cases, because different states have different rules for hearsay evidence. But you have to track it down. In other words, you got to chase this down. When you get an allegation against you, put that mother under oath. She needs to be under oath and tell her story of the DV that she's accusing you of. When did it happen? Who, what, where, why, and how? Where's your police report? Where's your photographs of your injury? Where's your medical report that this took place? If you don't have some of those things, you shouldn't have a case against somebody with a false allegation.
Mm-hmm.
And I had a gal arrested for filing a false police report on my client for domestic violence before. And it turned sideways on her. So there is ways to unravel these things, but that's being offensive, like you mentioned earlier. And that's a different mentality.
Sure. There's definitely the defensive, and then there's the offensive. Absolutely. And so I wanted to come back to something that you had said, Guy, earlier in the broadcast, which was about a diary and a journal and how that plays into evidence, and how important that can be. And because, again, a lot of times it's a he said, she said. Sometimes it's hard to get evidence, but how does the journal or the diary play in?
Okay. Well, first of all, I have people create that for me to give me the texture of the case, the chronology of events that took place, whether there was affairs, you know, when did you separate, how long you were living apart or together. And then I have a thing called the cast of characters, because I want to know mother-in-law, brother-in-law, you know, the children's names. I need to know all this stuff. So when they're writing the diary, I can plug it in and go, oh, Alex is the little boy and Tiffany's the little girl, and she's the one that's 4 and he's the one that's 6. And so I can get a picture of what's going on here. The other thing is it becomes, it helps people with their memories. So they're putting the timeline together, and so they're going to start thinking of, it's an exercise. And so they're going to start thinking of things that took place that they forgot about, or something that might be important, or something that was, you know, emotional that took place, or some injury that happened. And it puts something in perspective for the client sometimes, this cathartic reconstruction of what went on. And then it helps me give them advice and counseling about this, and recommendations based on what they're sharing with me. So it's just part of an overall exercise that I put my clients through. The other one I do is, what would you ask your spouse or your opponent, however you want to label it, if you had them on the stand? In your own words, what would you ask them? That's another exercise I do with them, because I don't want the attorney to have all the power with my clients. I want the clients to have some power. They know their case better than anyone else. We just need to direct them. And that's what I do for them.
Okay. All right. And so during child custody disputes, how do you advise approaching visitation exchanges?
Well, they're dangerous. I wrote my book a long time ago, and I've had to break up fights physically, people fighting, new boyfriend, mom's or whatever. He wanted to pick his children. I don't know if you saw one fellow shot picking up his kids. It was all over the news 4 or 5 months ago, I guess it was. Disturbingly sick, very sick situation. Take somebody with you as a witness if you need to. Take an off-duty police officer if you need to. Those are recommendations. I know people use their phones today to record and so on. Sometimes it's better to hire someone to record from a distance. So it's go early, scout for conflict, drive around the block a couple times. I mean, I've recommended all kinds of things with exchanges. Exchanges can make or break your case, though. And that's what I was talking to a client about the other day, is that he needed to show how the children didn't want to go with the mom, and the mom is abrasive, and so what's happening is the mom's attorney only wants him to bring the kids over. And I said, no. She needs to come to your home when it's your turn to go get the kids. You pick them up when it's your parenting time, and when it's her parenting time, she picks them up from your house. And we're going to show what's going on with these children, because when you take them, there's no conflict. When she comes to pick them up, they don't want to go, and they're older. I mean, they're not little kids, and they put up a fuss. They don't want to go. They don't want anything to do with their mom. It's a sad story, but he needs to be able to expose that. And so you have to have that ability to expose that. And visitation exchanges can be very illustrative from the standpoint of what you're able to expose, to show someone with a custody evaluator or a guardian ad litem or a judge, just what's going on here. Yeah. To show the how difficult it is that for these children, it might be toxic relationship that the children have with one of the parents, and it needs to be exposed. And sometimes there's not that many ways to do it.
We've talked about a lot of stuff, Guy. You've given us a lot of good information. Is there anything that I didn't ask you that you think is important in this conversation and for people to know?
Well, without touting my own skills here and all that, um, don't give up. But you have to surround yourself with the best people that can help you. And I help people find investigators, to help them with their cases in other states. And there's a lot of things. It costs money. There's no doubt about it. It costs money. But to take my course online is less than what a lawyer will charge you for 1 hour. And you're way ahead of the game of someone who's been doing this 30 years that knows the ins and outs, and it's very informative for these people. And so I think that would be something that they should really consider, even if they don't have a lot of money. This course is very comprehensive. It talks about how to use experts and also how to impeach experts, because you have to be able to improvise and adapt to the different situations. And this course shows people that. Mm-hmm. And that's what I do with my clients. I show them how to use the evidence, how to collect the evidence, how to use the evidence. And I always tell them they have 3 cases. What are the 3 cases? One of them is the case you have to make to your attorney.
Right.
They need to believe you. The other case is you have to make the case to the judge. And then the other case might be the case you have to make to a guardian ad litem, which tend to be useless throughout the country because they're just lawyers. And I have to shame them for their inability to get anything done and get any depth into the case. And then the custody evaluator is the other case. So you end up having with 3 cases when you have a custody evaluation, because mm-hmm. you have to convince your lawyer these are facts that are important to this case, and this is what evidence I want collected and pushed forward. And if they don't, then you have to move on and get a different attorney. And if you can't afford an attorney, I'm less money. I can help coach you through this process, and get a paralegal and file motions and try to get this thing turned around, because you don't have to have a lawyer in every case. Sometimes you don't. It's better if you do, but only if they're going to cooperate and go offensive for you in a high conflict case.
So we've got your website up, Guy, childcustodyguy.com.
Yes,
there have
ma'am.
been several people asking how to get in touch with you. And would you say that your website's the best way to go, or how can people reach you best?
Yeah, they can go to my website, fill out a form, get a 30-minute free consultation. We schedule it, I have a calendar, and we can schedule it and go from there. And then you decide whether you want to hire, or you got some information from me that's going to help you and you don't need me to stay on your case. But that's how I do it. So numerous people. I'm not too busy to take your call, but I have several people that fill out this form on a weekly basis, and I schedule those consultations with them.
And you've got your book as well, pulling that up. You can buy it on Amazon. It's Child Custody A to Z, Winning with Evidence.
Absolutely. See, we talk about evidence, and I have a chapter in there about common errors attorneys make. So I talk about personality disorders, and investigators, how to use them. So the book has some meat to it. There's no doubt. And it's been number 1 in its category for quite some time. So it's filling a void, because in child custody, it's all about psychology, and because we've had the custody evaluators dominate the custody determination over the last many years. And different states are different, like Pennsylvania, they use a guardian ad litem a lot. Arizona, they don't. California, the custody evaluations are expensive, but they use them. So it just depends on from state to state how much they do use them, but they've dominated this. And so decision making on the outcome of child custody cases were decided by therapists.
Yeah.
And it's good and bad because they get fooled. They get fooled a lot. And if anyone's read my book, they know that I have a personal experience from a family member that went through a custody case, and it was my brother. And the custody evaluator in that case, I met with him after the case because I couldn't meet with him before, during the case. But after the case, he told me, he says, without the evidence that you brought forward and helped your brother with, I would have been fooled. I would have been fooled. And so it would have had a different outcome because I was taking the stand to give a different outcome. But the evidence that you guys overwhelmed me with determined sole custody for my brother. So, and that was 30 years ago.
Mm-hmm. Well, great. Thank you so much, Guy, for joining us tonight and giving us all your advice and insight. It's been invaluable. Really appreciate it.
Thank you, Bianca. Take care. Have a good summer.
Thanks for joining us this week on the Peaceful Co-Parenting Podcast. I hope the time was well spent and you got a lot out of the episode. If so, please rate and review the podcast. I would really appreciate it. If you're interested in sending me a feedback message, asking a question, suggesting a podcast topic or guest, or downloading Peaceful Co-Parenting Messenger as a tool for better communication with your co-parent, go to peacefulparentapp.com or see the links in the show notes. Have a great week, and as always, stay peaceful.
This episode of Peaceful Co-Parent was brought to you by the Equal Shared Parenting Program. Do you find that you're ever in need of someone to talk to, like a counselor or a therapist? How about legal advice? If you've looked into it, you know these services can add up financially. That's why the Equal Shared Parenting Program exists, to help parents be their healthiest holistic selves. It's a membership program that offers discounted and free services like behavioral health, free tax prep and advice, and access to financial education and credit counseling, all for the low price of $29.99 a month. Learn more about the Equal Shared Parenting Program by going to equalsharedparentingbenefits.org/PCPM. The PCPM stands for Peaceful Co-Parenting Messenger. That's equalsharedparentingbenefits.org/PCPM.